Uh, Good afternoon, everybody. It's 12 noon, and we will be starting our session. Um, all panelists have joined us today, and we are ready to start. My name is Prateek Singhvi, and I am a senior associate at Shardul Amarchand Mangaldas with their dispute resolution team in Mumbai. Today, I have the pleasure of introducing our very vastly experienced and diverse panel that is going to speak on the issue whether international arbitration is a boon or a bane in developing countries. Today's discussion is sponsored by PNA Law Offices. The configuration of the panel is indeed very interesting. We have with us a government official, a senior advocate, and law firm partners. Their positions and experience set us up for an engaging discussion for the next hour. Um, and on a topic that is really both contemporary and commercial in nature. So the listeners will definitely have a good time listening in. On the panel today, we have four members. I start with Mr. Amit Misra, who's a partner at PNA Law Offices. Mr. Misra leads the dispute resolution practice at PNA Law Offices. Mr. Misra focuses on international arbitration and appears before various courts on arbitration related litigations. Mr. Misra also regularly advises the Government of India and various public sector undertakings in India on their dispute strategies. He remains connected to academia and is a visiting faculty at NLU Delhi and Jindal Global Law School. Welcome, Mr. Misra.
Thank you.
We next have Senior Advocate Pinky Anand on the panel. Dr. Anand is a senior advocate with a diverse practice in constitutional, civil arbitration, and criminal law matters. She's a former additional Solicitor General for the Republic of India and is the second woman in India to have held this office. She holds a master's degree in law from the Harvard Law School. She is registered as an arbitrator with the Dubai International Arbitration Center and a registered legal practitioner in the IFC courts. She is also a member of Number 5 Barrister Chambers in the UK as a door tenant. She has represented India in various national and international forums, including BRICS and SCO. She is the governing body member of the Indian Council of Arbitration and associate members constituency of India Council of Arbitration. She's a founding member of the BRICS Legal Forum, and she is also the vice president of the Bar Association of India and has been actively associated with the Bar Association of India for several years in various capacities. She has authored several books, including Trials of Truth, which was published by Penguin, uh, International Relocation of Children in India, that was published by Thomson Reuters, and Family Law Jurisdictional Comparisons, which was also published by Thomson Reuters. Welcome, Dr. Anand. We next have Mr. Madhvendra Singh on the panel. He is a senior Navy officer who is currently appointed in the Ministry of External Affairs, Government of India. He is a qualified and experienced international arbitrator and a fellow CIAB London, fellow at the CIAB London. He is an alumnus of Queen Mary University, London, and the South Korea Maritime and Ocean University. He is the supporting member and arbitrator with the London Maritime Arbitrators Association and is an advisor to the Indian Ocean Rim Association. He is on the governing council of the MCIA Maritime Users Council and is a member of the LMMA, the MARC, and other international institutions. He is a reputed arbitrator and he is also a negotiator and has participated in many negotiations on behalf of Government of India in relation to treaty work. Welcome, Mr. Singh. We finally have, last but not the least, Mr. Roy on the panel. He's an attorney with Foley Hoag in Washington, D.C. His practice focuses on investor state and international commercial arbitration, as well as arbitration related to litigation before US courts. He represents sovereign and private clients, both before arbitration panels administered under the ICSID, UNCITRAL, ICC, SIAC, and other ad hoc arbitration rules. Sudhanshu has represented a number of Asian, African, and European states and state-owned entities in several high-stake investment arbitrations and international commercial arbitrations for over 12 years now. Sudhanshu also represents sovereign and private clients in the international litigation and arbitration matters before US courts in the New York and District of California. I welcome the entire panel, and I will now hand it over to Mr. Misra to start with the proceedings.
Thank you, Pratik, for this lovely introduction of all the speakers. And I welcome all the speakers here as well as the participants for this next 1 hour, where I hope that we seek to answer this question, which is a topic of the session today, whether investment arbitration, is it actually a boon or a bane for the developing and emerging countries? So in order to, before I call upon the speaker, I just want to introduce the topic by giving my initial thinking of why this topic has been chosen for this next 1 hour of session that we intend to speak upon and deliberate. So basically, the debate that all of you know, which is going about this bilateral investment treaties, is actually split between two camps, if I can say so. In particular, those who maintain that these BITs or the investment arbitrations, they actually encourage the investment or the FDIs in the developing countries, since it provides enforceable rights and protection for these investors who are securing their belief that once they are coming into the country, they have their protection in place should there something go wrong with the investment from any action of the state. Whereas, on the contrary, there is a very significant, very convincing argument by the second camp, which says that these rights or protective rights being conferred on the investors have indeed effect on the regulation for public and environmental welfare, and actually the argument being led there is that it hinders development. Instead of encouraging the development in such developing countries, the protection that the state is giving, whereby curtailing its own right to secure what it can legislate for its citizens, is something not worth the protection for this investment which is coming into. So while over this one period of 1 hour, we'll deliberate into this, and I of course look forward to my esteemed speakers here to give their views on this topic. I have, may I call upon Ms. Anand initially? Ma'am, can you throw some light on the topic itself as to whether, in your view, the BIT arbitrations you feel itself is a boon or a bane for the emerging and developing economies in general?
Amit, thank you very much, and Pratik, thank you for having me here. It is indeed a delight, and in the middle of the day, even more so. Normally, we land up with very strange timings at bit. But coming to the subject at hand, the BITs, whether it's a boon or a bane, and indeed, it's a very difficult world. When you're dealing with the concerns of the developing and the developed countries, when you're dealing with the concerns of the developing countries, which include development, at the same time concern for environment, human rights, other issues of sovereignty that come across. It's a crossfire at the least. So I don't know whether we can ultimately ever come out with a consensus on this, but the position is this. I mean, the reality check is this, that India, for example, has been having an FDI flow of 2021 and 2022 of about 83.57 USD billion. And this has increased about 20 times in the last 20 years or so. And particularly even post-COVID, incidentally, there has been a large increase in the investment itself. On the other hand, you have, as far as BITs are concerned, you have about 37 disputes pending at the present point of time. You have terminated about 77 BITs. You have signed only 4 since the model BIT came into being in 2016. And we are now renegotiating with about 37 countries. So if you look at the entire chart and the circumference on this subject, it appears that we are having tremendous difficulty with BITs. And at the least, we need to really revisit our position on BITs. We can't afford to have so many disputes. We can't afford to have so much vagueness. We can't afford to have so much protection as we have sometimes circumscribed for ourselves. We can't have so much protection for the investors as we wanted to have. At the same time, now we've diluted in our various forms of model BIT. We have to consider various options such as ICSID, to sign into the ICSID. We do have to consider what we have done with the model BIT. I mean, just as a matter of discourse, the whole watershed really has arisen from White and Case after we lost out and following on the MFN clause as it stood. So ultimately, in the model BIT, we quickly diluted it. and we removed that MFN clause. So basically not giving that most favored nation, which is very particular in BITs. We also tried to do, for example, changes in enterprise definition. We tried to widen it, but it is totally vague. We don't have where it is, how long it is supposed to be, what is the duration of it. Investment, again, is something we have dealt with. We've similarly also, for example, dealt with the issue of the investor having to exhaust all domestic remedies for 5 years, which indeed is one of the most critical issues, that can you be forced into this kind of forum when you are dealing with situations. You also have, at the same time, in the model BITs, the fact that we are exposing investors to various difficulties on ground in India. And we, because of it being a BIT ultimately is an agreement between two countries to give each country, an investor from each country, similar rights. So ultimately, we are again struggling with that concept. If we give difficulty to investors, we are going to face, as India goes, similar difficulties in countries outside and the same kind of broad platforms. So having put out this very broad kind of key points on the subject, I think that we have not had a tremendous success with BITs. There has not been a amazing link which we might demonstrate that BITs have actually shown a great future progress into investment into India for FDI. So for us to say that we do need BITs is a big question mark, according to me. And at this point of time, we do need to re-examine our existing model BIT, which came into being in 2016, particularly because of the experiences. Incidentally, the globe is also struggling. And I know that you might have some questions later, so I'll respond later on that part. But developed countries are also facing similar problems. It is not as if it is only for developing countries, because this crossfire between development and protection is something which is always a current situation. But what we do need to do, Amit, when we are talking about this is, whatever we may do with BIT, whether we ultimately retain them, whether we have a hybrid of BIT, and possibly there is now a talk of a special law also on the subject, which may protect investors, as some other countries have in particular. For example, South Africa has that kind of legislation. We do need to consider to bolster up our own judicial regime. We do need to ensure, for example, we've had the Commercial Courts Act amendment. We brought into being a completely different regime, and we are now, like the law minister was saying recently, from about 1,000 days plus for disposal of a matter, it has come down to about 400 days. So if we can't improve our system more, we will give the maximum confidence to any investment regime if we can give investors possibly equal rights to domestic investors with domestic investors, as well as give them a safeguard of a judicial process that is efficient, which is loaded in favor of both parties rather than a single-sided loading. Due process is something that we do really need to concentrate on. And incidentally, we've been doing that across the judicial platform, in the sense that we've seen lesser and lesser intervention as far as courts are concerned. But I believe that BITs by themselves don't seem to signal in anything very major for the country. And we really can't do only with BITs as a concept. We do have to consider them in line with a hybrid combination of other things, while at the same time bolstering up the BITs. We can have them. There's no difficulty of having BITs. But right now, as we exist, we are not able to give full justification to the net effect of that on the economy, or to the benefit to India as a country, and the concerns that India would have as a country. And we are having FDI flows coming in on a very large scale, which would seem to offset the theory that BITs have a direct connection. In fact, there is no causal connection that anybody has really found between BITs and FDI. It's a general statement made, but there is nothing to really demonstrate that. I believe that we are at a stage right at the threshold of going forward in a different way, so that we can actually protect investment, encourage investment, protect India, and ensure that the economy takes a foot forward, as we are discussing.
Thank you, madam. In fact, for your very detailed and deep insight into how, in your view, actually BITs, as you said rightly, there seem to be no direct causal relationship that FDIs will stop if there is no BITs, or FDIs will increase if there is a BIT. Of course, that's a very powerful argument you make on how there is no direct relationship there. So at this stage, picking from there itself and continuing that thought, can I invite Mr. Singh, Madhvendra Singh? Mr. Singh, in your view, as this is what ma'am said, and continuing from there, and of course, asking you to all your view on whether it's a boon or a bane, but also particularly asking you whether you think that absolutely it's required that the country must have a strong BIT in place for FDI investment to flow in. As ma'am said, India has almost terminated all its BITs, but a record FDI investments continue to flow in. So what's your view on that? Does it for developing and emerging countries generally, is a BIT a must to attract investment?
So thank you, Amit. Thank you for inviting me, Pratik. Thank you for the introduction. And good afternoon, everyone. So this duality of good and bad, the boon and the bane, would always continue to remain with almost everything. So as regards the BIT is concerned, we must see why we are talking about this subject at all today. We must understand that why we have actually reached this point as far as India is concerned. In fact, when we signed the first BIT in the 94 with UK, we actually adopted the model BIT of the 93, which was based on the UK's template. So the template we started to use at that point in time was itself investor friendly, as we can call it like that. So that's when it all started. In fact, we took a lot of credit for having signed more than around 80 BITs thereafter in up to 2000s. So that was a good thing, unless actually speaking, the Enron case should have was actually the canary in the coal mine. But we actually ignored that. We didn't learn our lessons. And also, if we see that the customary international law at that point in time, when India was getting into the BITs, did not really have much of jurisprudence as far as the investment arbitration is concerned. So there were no lessons learned. It all came down to the White Industries case, where actually it split the temporal landscape in India to the before and after. And that's when we went ahead and actually learned our lessons, and we drew all our BITs to more than 70 countries then, and then came up with this model BIT in 2015. So if you see, what actually was happening was that the investors were actually challenging the legitimate domestic regulations which were created in India. And the things like the full protection and security clauses were actually made absolute flow tests, whereas they were not absolute obligations. If you see today's customary international law, these are not the absolute flow tests. So if what we have done with the model BIT is, and also with respect to the earlier Australian case of White Industries, we realized that the most favored nation clause, which India had with the Kuwait BIT, was actually adopted and used against us. And in that matter, if you realize that matter, when it went to the International Tribunal under ISDS, was not awarded on the merits of it, but actually on the effective means of basically bringing in the claims and providing justice. So that clause of denial of justice was actually made as an absolute performance on part of the state. So what India has now done is, see, what I'm trying to say is that existence of good or bad does not really matter. BIT may not be the sine qua non of foreign investment, but it does affect, if you compare the legal entities and the private investors would probably know the landscape of India, know the investment environment, the stability of the government. They're okay to come inside. But on a larger context, I think any kind of a formal agreement between two parties would provide some kind of a confidence for the parties to come in with their large investments in their country. So what happened with the developing countries as such was that, because after the World War II, all the colonizers actually, they came up with their own template of BITs, which was to protect their investments, and we adopted that model. Now, as we are learning our lessons, I think we are retracting those models and coming up with our own models. And of course, what we are adopting is not any template, so to say that model BIT is a good template, but still when we are going into negotiations one-to-one with our specific countries, where we have good diplomatic and strategic engagements, we are actually iterating these model BIT also to that effect, as it basically suits both the countries in their trade relationships. So I think saying that BIT is good or bad is not the right context to give. It's actually how we utilize the BITs, of course, because the global ratings of ease of doing business is important. People need to have the confidence in a particular investment environment in the country that government is not going to take manifest arbitrary policy decisions which may affect the investments in the long run. So that is what, considering those, I think the BITs may not be the sine qua non for investors, but it may be required to have a formal agreements. And what we can do is go like one-to-one with the countries that we want to engage with, and then probably utilize our model BITs. In fact, we are doing that. We are engaging with more than 37 countries now, and we have signed BITs with 4. So I think that is what I would like to say about it being a boon or the bane.
Thank you, Mr. Singh, that for saying that it's not really a sine qua non, but at the same time, for ranking of the ease of doing business and for other factors, investment environment in the country, actually sometimes is required, and it's very difficult to do away with. Of course, that very thin line balance is something I understand we have to achieve, especially when it comes to emerging or developing countries. At this stage, could I invite Sudhanshu, you to weigh in on your thoughts as to basis of what you have heard the previous 2 speakers, and in your view, you really think that for a developing country and emerging economies, it's important whether to tread that thin line balance of trying to justice to the investors as well as protecting the rights of the state, or you think it does increase, because for a developing economy, it's very important to be an attractive destination, and for various other factors, it's important that there must be more friendly environment regime through BITs. Yes, Sudhanshu.
Thank you. Thank you very much, Amit. And thank you to Prateek and all the other speakers for their very insightful thoughts. I mean, I largely agree with whatever has been said so far. Honestly, this question, whether BITs are a boon or a bane, whether they are a major disadvantage or an advantage to developing countries, it's a very difficult question to answer. But that being said, this is a question that, I mean, as counsel, as someone who works on these type of cases, often I don't think about it, because when you're working as counsel, when you're working as lawyers, you actually are in the weeds, and you're in the daily grind of representing your clients. But sometimes it's often good to take a step back and look at the bigger picture. So certainly, from the perspective of policymakers, government officials, and people who are invested in good governance issues, especially in developing states, this is a very important topic and something that I personally have come across very, very often. So, as I was saying, I agree with the other speakers that there is no right or wrong answer to this particular question. In my view and in my experience, despite all the shortcomings that people have mentioned about investor-state arbitration, and we've been hearing all of this for the last, I would say, at least 10 years, 15 years. On the whole, the system has been a success. I mean, you only need to look at to evaluate whether any judicial or any dispute settlement system has been a success, or whether how effectively it is working. You need to look at whether the people who access the system really benefit from it. So on the whole, if you look at the numbers broadly, you would see that everybody, all the stakeholders who participate in the investment arbitration system do derive certain benefits from it. It's not like developing states who are subjected to lawsuits or are subjected to these type of arbitrations are always ending up on the losing side. I mean, statistics as a whole bear the reality that I think I haven't looked at it recently, but the statistics are something like 35% of the cases are resolved in favor of the states, which includes developing states, obviously. Around 30 to 35% of cases are resolved in favor of the investor, and the rest are settled. So on the whole, the system has been working for everyone who's participating in the system. But that being said, no system is perfect, right? So we have always got to work on improving the system as a dispute settlement system. There are certainly many shortcomings with the investment arbitration system. We can go on and talk about it endlessly, but it is reasonable to assume, at least partially, that investment treaty arbitration is a reliable dispute settlement system as a whole. I'm saying. I mean, you can talk about the specifics, and I mean that's basically summing up my view. And I certainly have worked a lot with the states. A lot of my work has been with sovereign states, as I've especially in Asia, especially in Africa, a lot of developing states. So I have seen the, it's not like I'm, talking or taking the side of one particular side. So I have seen the picture from both the sides. And therefore I would urge caution, in arguing that we should completely abandon the system or we should dump it in favor of something which is completely different, because I think the system as a whole works. And I think at the beginning of this panel discussion, I think, Amit, you were the one who were mentioning that there have been increasingly, for example, investors from India who are accessing the system and initiating arbitrations against foreign governments. So I think that's another very valid practical reason why we shouldn't, be in a rush to kill the system, because the developing states of today are the developed states of tomorrow. I mean, India is a so-called developing state, but at the same time, we are probably the third or the fourth largest economy in the world in terms of purchasing power parity. So, and we have vast number of, Indian multinational corporations which are investing in foreign companies, or foreign countries rather. So these companies, these corporations face political issues, face legal issues when confronted with an alien environment in a foreign country. And, in that case, although when you're looking at it from the government side, when you're looking at it from the sovereign state side, there are problems with the system. But when you look at it from, if your outward investment flows, the system actually may work because it provides protection to your own investors who are operating in a very foreign and alien environment. So I think that's one reason. I mean, I could give another reason. For example, depoliticization of disputes is another very important reason, and something which is very well known. But if you look at, for example, the current war that's happening in Europe between Russia and Ukraine, and by proxy between the European Union and Russia, there are, the atmosphere is highly charged. There are, I mean, it's literally, there are people being killed and bombs being, infrastructure being devastated in both countries, and, a lot of political, highly charged political rhetoric everywhere. But at the same time, if you look at it, there have been many, avenues for investors, for companies from both Russia, Ukraine, and the European Union to litigate the problems that they have faced in connection with this ongoing war in a neutral and less politically charged and less toxic environment, where, three arbitrators or one arbitrator could sit and adjudicate the dispute in a very neutral and sort of, as I said, non-political forum. So, I mean, these are some of the reasons, and we can go on and talk about this. But as I said, the conclusion, there's no easy answers to this question. That's what I would like to say.
Thank you, Sudhanshu. As you definitely rightly said, there's no easy answer to find to this debate as to whether it's a boon or a bane. And of course, as you said, developing countries of today are developed countries of tomorrow, and it's very difficult to have that comparison whether the developed countries, BITs, have done more good to them than BITs for the developing countries. But and of course, the debate is becoming interesting, where there's one set of views saying that it's not really working out, or not, really having any causal relationship with the FDI incoming. While, of course, there is a very valid second side of the coin, where it means that it's too early. It's best to, as you rightly said, Sudhanshu, to have a caution, and best to tread a line of balance between protecting the rights of the state and the investor. But moving on and maybe deliberating upon a second set of really a concern that from a state perspective we see is that many of these PIT claims are actually targeted, or if not targeted, are brought upon when the state they go upon and legislate for on issues say which are about the public welfare. So most of these policies which come about for a public welfare or something is done to say strike down a corruption without going into names of it. We have seen recently where certain actions were required or compelled to be taken to strike down a certain corrupt acts, or maybe to bring about more beneficial policies for the public welfare. It does affect some investor, and we see a BIT claim being brought upon by the state against the state. So on this, basically what I wanted my panel of speakers to go into and express the views is, do you think while it's necessary to have them, but maybe as a developing and emerging economy, we should see that there are more of exceptions, like the model BIT where it mentions taxes and can't go into, right? So we have seen that for a case of India where model BIT says that. So while we can agree or disagree whether we have it or not, but if we have it, does it make more sense to have a wider exceptions or a defense for developing countries included in the BITs? What do you say, Mr. Singh, from your experience on this issue?
So, Amit, I think Dr. Anand and Mr. Roy have already taken two sides of the ring. So I'm basically happy to be a referee here. So as long as, see, the states must protect the right to regulate. That's where the whole debate is all about, bringing in that balance about the protection for the investors versus the right of the state to regulate. So what happens is when the government goes making on policies for the betterment of their own people, that might sometime be construed by the international tribunals to be indirect expropriation. But when the tribunals actually look into this particular aspect of dispute, they must actually look at from the perspective of intent versus the actual economic development that has happened through that policy change. Whereas one of the most problematic areas of ISDS claims have been the lack of transparency in these tribunals and lack of consistency in making of these decisions, which also actually emerges from lack of any appellate authority, which has been a big concern for India. Because the award comes out of, let's say, we are not a signatory to the Exit Convention, but claims can still be brought under the Exit Additional Facility Rules. If an award is given by the Exit Tribunal, let's say, you have nowhere to go except enforcing it. So India, in our BIT, we have actually brought in a lot of exceptions, but we have given an appropriate measures to basically mitigate those. Like, for example, the most favored nation clause, we have given an exception, we have not included it, but what we have said is that any conduct of the state must not be against the customary international law. Similarly, we have given an exception for the FET. We don't have the fair and equitable treatment, but we have said that we have actually included in the chapter 2 about the treatment of investments. So that's where it is covered. If the claim has to be brought, it cannot be said as an FET, but yes, it can be brought under the treatment of investment claims. Similarly, for the full protection and security, actually, very frankly speaking, having read a lot of tribunal awards and getting into the negotiations of these treaties, FPS is not an absolute requirement. It's not an absolute liability on the state, because that whole concept of full protection and security actually comes down to the physical security of the foreign investment or the assets that they have. It cannot be interpreted into the policy frameworks which must protect and promote their investments. That's actually not the part of the deal. What actually it means is that you're basically providing the physical security, and that's it. And also with the FET, when it happened, there was also a conjoint concept of legitimate expectations. There have been times when investors have picked up the political manifestos of parties which have risen to power and taken them as legitimate expectations. I mean, that could be, extreme ends of how you would take legitimate expectations of who are the people who can actually, whose, let's say, words can be actually taken as legitimate expectations. And then also, when we talk about the fundamental breach of the due process that we have talked about in the model BIT also, what exactly this fundamental breach means. So there is a little bit of ambiguity and provides an amount of discretion for the tribunals for interpretation. And also, if we realize these treaties are actually lex specialists, and the customary international law actually is a lex generalis. But what happens in the interpretation after a breach interpretation of these treaty clauses, the tribunals land up in making these interpretations based on the customary international law rather than on the actual explicit language and the intent in the preamble of that particular treaty or the BIT, which must be avoided. So India has very, efficiently come up with this model BIT, which a lot of people, many experts, both domestic and international, would feel are not necessary. But once again, I'm mentioning this, that the model BIT is a template, but when we are going into the negotiations, it depends on both the countries, how much they're willing to accept or not. For example, the exhaustion of the local remedy clause of 5 years that we have, plus 1 year of after having known the causation. So this is being negotiated. I mean, what exactly we lost to in the case of white industries also was basically not providing that, that forum for bringing in claims and basically enforcing the rights. So that's basically a judicial problem. And although they recognized, the tribunal recognized the fact that Indian judiciary is overburdened with a number of commercial cases and matters that are pending in the courts, which does not really, is not a legitimate excuse for not providing, because it went on for 9 years in the Supreme Court itself. That is understandable. These things are understandable, although the tribunal did not give anything on the merits. So these are the concerns I think are very well addressed with our model BIT. And as we are engaging one-to-one, it is providing us enough opportunity to basically negotiate our terms for the mutual benefit of both the parties which are getting into this. In fact, most of the international treaties and organizations do have a monolithic character actually. If you see, many of these developing countries are actually withdrawing from these kind of treaties and international organizations. And you see a lot of debates, and our external affairs ministers also gone to the UN and spoken about it, how there must be reforms in the United Nations itself, how the international organizations are working, and how it should bring in more transparency, it should bring in more decentralization of power. So that is what, in a sense, is that though India is, as a country, all developing countries, we must do follow a BIT is important in that sense. And however, but the way we deal with it, the way we deal with the exception clauses is basically has to be whole encompassing.
Thank you, Mr. Singh. Of course, way you have, behaved in the sense mentioned about how it's best to be a neutral and not really take a stand on either side, which the other speakers are taking. At this stage, as you mentioned, it's sometimes advisable to have a BIT, like we have a model BIT, and where you are saying it's more, more focus could be given on strengthening the judicial system and access, and of course, ensuring that the, the investors don't have really a reason to have a recourse to a BIT. Something what, Madam, you also mentioned. At this stage, what can I invite you to weigh in your thoughts on? You think, ma'am, I know you said really it's not really worked out in your opening sentences or remark, but you think, can we keep BITs in place, but have them because it really addresses the concerns of ease of business and investment environment in the country, while it may not really have a casual or causal link with the FDI, as you mentioned. But do you think that having a flexibility, as Mr. Singh was mentioning, while the BITs are now being renegotiated, while a state is entering a new BITs, maintaining that flexibility on what to have it, because we have really seen the picture over the last 5, 7, or maybe 10 years, and using that experience to re-enter a new BITs, but yet not completely do away with it. Do you think that would be a more pragmatic approach, ma'am?
Amit, actually, you are right, and Mr. Singh, to this extent that when we talk about one way or Jose, so to say, so there really sometimes is not a clear answer. I was ultimately only saying because of the difficulties that have arisen with the BITs and their enforcement and these specific issues that have arisen, this has led to some complications which may be well be sorted out by other means. For example, as I mentioned, a special law to deal with foreign investments, which could also come into place. But ultimately, these are hybrid combinations. All countries, all of us ultimately experiment, we develop, we revisit, and at this process, we are constantly revisiting. In fact, the Standing Committee on External Affairs, which recently examined the issues of BITs, came out with a very comprehensive document and suggested, for example, definitely revisiting BITs. So one thing Mr. Singh said is absolutely right. We have a model BIT, while they exist, let's talk about it at that stage. While the model BITs are there, it is up to us to negotiate and renegotiate. Of course, the negotiations are premised on certain sovereignties of countries and the interaction, which ultimately puts the same into place. So we can negotiate to our satisfaction. But one thought I have on the subject, aside from a special law concept that we talk about, and we are talking about it, we also incidentally have the PCA system into place. There's an agreement with the Permanent Court of Arbitration, which has been noticed by the Standing Committee also. And we can ultimately approach this as a method of resolving disputes. But my one thought is what Australia, for example, has been facing, this entire concept of expropriation in the context of labeling of tobacco products, which has come into several claims, and possibly even the trade notice comment of UNCTAD, which was a few years back nonetheless, but reviewing the entire situation, that we should not at this stage, and particularly I'm talking about India, talk about special protection for investors. And that is something that Mr. Singh also voiced when he was talking about it. We actually should talk about a parallel system. What is the whole concept of BIT? The concept of BIT is to ensure security for the foreign investors as well as the concerns of the host state. India, of course, has some specific concerns which are not being met at this time. So the most favored nation clause, for example, was completely out of context as far as that is concerned, and White in case went completely the other way. Frankly, there's this entire concept of a prudent investor. A prudent investor knows which country is investing in and what should be the expectation. So to actually come around, White in case is that watershed, which we've learned tremendous amount of lessons. But possibly what we do need to think when we are renegotiating, these 37 BITs are in the process of renegotiating as we talk. When we're talking about is to ensure some reasonable equality to foreign investors. What foreign investors really want possibly is they may want a preferential treatment, but really speaking, they want protection that they are not discriminated against. So I think you have to veer around a lot more to that concept of saying domestic legislation in any country, as long as it doesn't take away any substantial right of investors, is something that should govern the rights of parties in BITs. And if you're able to meet that, we will be able to develop ourselves as much as to ensure that the investors also understand that they are coming into a country, for example, like India, which has the fourth standing in the world in the global economy as far as purchase is concerned. And therefore, the investment is welcome, but the investment has to be ultimately on terms that are acceptable to India as a sovereign nation. Now, you mentioned taxation, Amit, when you were talking. Taxation has been excluded in the domain of the model BIT, of course, subject to any further discussion. Following again the aftermath of Vodafone, that again needs to be looked at fairly closely, because can you discriminate? Should you discriminate between a foreign investor on any ground if there is provision for exemption? And thirdly, I'd like to flag one issue: specific exemptions. We must avoid too many exceptions. We must avoid ambiguity in exceptions even more. So, I mean, this entire concept I spoke about, investment, enterprise, these are concepts which are subject to so much of sometimes of vagueness that they lead to a lot more disputes than we can imagine. So we need to kind of tweak our BITs definitely to ensure that there is as much certainty. The more certainty there is, the more rule of law there is. This is the basic principle of democracy of law, as we might say. So therefore, we need certainty in our definitions when we are putting down to terms the actual BITs as compared to the model BIT. Model BIT is a way forward. It was 2016. We are considering it, but tweaking at the stage of negotiations and finalizing the BITs is something that we do need to put into place totally. ICSID also I had flagged as a concern, because a number of countries, a large number of countries are members of ICSID, even though incidentally, as we speak, some countries are choosing to get out of ICSID. 3 countries have chosen to get out of ICSID too. But ICSID is another common international platform that could be considered. And while we as India do believe in our sovereignty and continue to believe so, we must ensure that we have an international platform so that everybody is at a common page in terms of resolution of disputes so that it is satisfactory. And finally, just one last statement on this aspect. I do feel that the arbitral tribunals sometimes are more investor friendly than otherwise. There is a bias, and that bias possibly has to be considered on a two-way street. And the concerns that countries have, if we have BITs, the idea is to ensure the protection of both. And definitely, the principal concern is also of the host country, because how is an investor going to benefit from a relationship with the host country unless and until the host country is able to take its own agenda forward? So that investor friendly bias has to definitely give way to an equal way traffic for both.
Thank you, madam. Investor friendly bias. Yes, I hope someday definitely there must be a detailed study on this, because even we represent a lot, and to state and of course that's a matter of another debate once we have a little more in-depth study and data on it. But Sudhanshu, calling upon you, what ma'am said, why we are extra for a foreign investor? If you can strengthen your judicial system, and in any case, if you are legislating and going in for a new BIT with so many exceptions and things being carved out, what you can't do a BIT for. So instead of really doing that, why, as ma'am says, and as Mr. Singh also said, why can't a domestic investor, and taking a context of India, where almost all the BITs today are not in place and still a record investment is coming in, since you had mentioned that we must exercise caution, not really going into a old question, which I think you have answered, that it's not really an answer of Boon or a bane. But I think the key argument which is coming so far is that these treaties, BITs, elevate the right of the foreign investor as compared to a domestic investor within the country. Is there really a need for that? Did we really elevate the rights of the foreign investor? Or you think the domestic laws still then an equal access and judicial thing which can be quickened and fastened, that can give equal confidence to the investors? Sudhanshu.
Yeah. Yes, Amit. No, very, very interesting discussions. No, I mean, I think that certainly, again, there's nothing much to disagree with what has been said. There's certainly a case for carefully balancing the sovereign right of the state, the right to regulate of a sovereign state, with the interests of a foreign investor when you're negotiating BIT. Certainly, there cannot be any dispute about the fact that a state has to carefully consider its defensive position when acting as a respondent in these investor-state arbitrations, when negotiating those treaties. So I don't dispute that point. As to your question, whether these treaties elevate the status and rights of foreign investors, I mean, certainly they do, because they provide foreign investors with access to a system of dispute resolution that is not available to domestic investors. But again, that being said, when those domestic investors, for example, would go to a foreign country, right, they would have access to BITs that have been negotiated. So when by the host state. So, for example, if Indian investors go to Mauritius and invest in Mauritius, they would have the benefit of the India-Mauritius BIT, which is although now terminated. But I mean, there have been examples where cases have been initiated under the India-Mauritius BIT on both sides, by foreign investors against India, but also at the same time by Indian investors against the Republic of Mauritius. So there is, we have to look from the both sides. I mean, and from my experience, again, speaking purely as counsel, I have worked on a number of these type of cases under treaties that were drafted, let's say 30, 40, 20 years ago, and treaties which were very recently drafted. So, I mean, I have seen all kinds of disputes. I've seen, disputes which were adjudicated under very carefully and very, very, I would say, modern drafting of modernly drafted provisions, which sort of protected the the right of the state to regulate in public interest. So I have seen both those kind of disputes, but ultimately, no matter what you write in the treaty, no matter what kind of clauses you put, the arbitral discretion that it's the same as judicial discretion. The discretion to interpret and apply that provision always remains in the hands of the tribunal. So, you'll also have to be, and I think Ms. Anand was saying this, but you also have to be careful about putting too many words in the treaty. And one example that comes to mind recently, it's a long ongoing case, but I've been involved in a case for a developing state, again, Asian developing state, where one of the main defenses that we have in that case is that the investor engaged in corrupt conduct in the making of an investment. And there's an ICSID case. There's a case under ICSID. So if you know, ICSID has a very well-developed jurisprudence, very well-developed rule of law on the fact that any sort of corrupt conduct by an investor in the making or procurement of an investment automatically precludes the jurisdiction of an ICSID tribunal on the grounds of violation of international public policy. Basically, corruption is prohibition of corruption is a rule of international public policy, and ICSID tribunals take it very seriously. So there is, that well-defined rule of law, body of law that exists, but when it's actually applied in some of the cases, the outcomes are absurd. So in the case that I've been involved in, there is actual evidence of corruption on the part of the investor. So there is a guilty plea that the investor entered into in its home state. So from the state from which it invested into the developing state, it admitted that it bribed one of the ministers that was involved in the approval of its investment. But that was not enough for the tribunal. That's where the absurdity comes from. So despite evidence, despite an admitted guilty plea, the tribunal held in that case that there is no concrete causal link between the guilty plea of the investor and the procurement of the investment. The tribunal basically said that yes, the investor admitted that it engaged in corrupt conduct, but then there is no direct evidence to show that corrupt conduct procured its investment. That sort of evidence, especially in an international arbitration proceeding where the rules of evidence are not so strong, is almost impossible to find. Where would you find, somebody admitting that, yes, I paid this much amount of money to get an approval for an investment? The fact that the minister who was responsible for approving the investment was bribed was not enough for the tribunal because of this lack of direct causal link. So as I was saying, these things are, these rule of law protections and standards of protection are always there in investment treaties, but ultimately there's a lot of arbitral discretion. So perhaps we also need to, focus on the standards of evidence, for example, that we apply in these type of proceedings. Whether for corruption, especially, whether there is always there must always be a requirement of direct causal link, or whether circumstantial evidence is enough, things like that. So there are many issues to consider, but certainly I would agree that as a whole, states must balance the right of investors to access these treaties with their own right to regulate in sovereign and public interest under their domestic and international law.
Well, I think we are almost approaching to our close time. A very interesting debate, which I only hoped should have continued. But as everything good thing comes to an end, maybe what I do foresee is that what began with a very diverging view of no, it's not really worked out, to to something like it's very much necessary to have an ease of business and for various other factors. What I do realize over this 1 hour period is that we have almost come to a conclusion to see that it's good that the developing countries, and of course India also in perspective, is using the experience and all the criticisms and the advantages that we have seen over the last 10 years while we are renegotiating our BITs based on the new model BIT, and of course as ma'am says and Mr. Singh says, and of course Mr. Roy also weighs in, that the processes are important. Equally, the judicial system in India is equally important. No need to really elevate the rights of foreign investor, but at the same time, it's here to stay. It's not really a boon or a bane. I think it's here to stay. The best thing and the only thing we have done, hopefully, in this one panel discussion is to really throw out, maybe something neat to for the people to note that what are the areas where you should, look into while re-entering new BITs or things which are important from the investor perspective. Maybe as a concluding remark, ma'am, anything on the topic? I know it's just 5 minutes left. So maybe all of us can give one concluding remark each.
See, what I can say is that ultimately we as a country are looking forward to this entire prospect of dealing in FDI and investment. And as long as we can tweak our systems appropriately, keeping in mind the developments that are happening, it is ultimately still an opening regime. I mean, we started from a socialist kind of era in economics to globalization in 1990s and then opening the way forward. So we have from time to time considered our options. And even as we stand and we speak, the government is also consciously looking at this with the standing committee and the deliberations that are happening. We have reached further and we can still continue to do so. What I liked is most of Sudhanshu's comment, which is that model BIT, we might be critical of some of the aspects as they stand, but that is ultimately a legroom to stand on. So it's not a final stage. It is something that can be revisited. And I am today very hopeful of a hybrid combination in any case. If BITs are needed to give confidence to investors, which we all need and we want to develop, well, so be it. But maybe we should just consider the lines that today is a time when India is standing strong as a giant in the global field. And we can consider equality of treatment to domestic investors as an option, whichever way, whether through the BITs or whether through a special law that ultimately entails that. But specificity and equality is possibly today more the order of day than other things. But the arbitral tribunal's viewpoint on fraud, incidentally, Sudhanshu, very well taken. I was instrumental in one of the international arbitrations that dealt with the question of fraud and ultimately had the arbitration thrown out on that account. And you're right on the standard of proof. I think fraud is a complete no-no, if I might use that expression. Fraud and corruption has to be opted out, and there's no way out of that situation. The standard of proof, circumstantial, is getting to be a way of life in most criminal jurisprudence, even otherwise. Why not in the field of arbitration equally? So that you safeguard. You cannot have a country's sovereignty being taken away by any foreign investment of any country. I'm not talking about India right now, I'm talking about the global picture. So these best practices of exit tribunals and customary international law are something that have to be taken completely at the original value so that we as a country means any country, is not taken for a ransom on any concept of investments. So with that, thank you very much, Amit, and we look forward to further deliberations.
Thank you, ma'am. Mr. Singh, any final comments on the topic?
So thank you, Amit. I know MCI is very, very strict about the timing, so I'll just take 30 seconds to sum up. I agree with what Dr. Anand has said, but that tribunals are very investor friendly, investor oriented. But that is how everything is. We all like underdogs. So you have to play your cards well. But as far as the BIT goes, I could agree to the point that having mindless application of exclusion clauses may not be the right option. But having those clauses with more meaningful clarity and certainty in their clauses is what is required actually. But I'm also happy that Dr. Anand has shifted her point of view and acknowledged the importance of BITs to have. So thank you.
Okay. Sudhanshu, concluding remark? You're on mute.
Sorry. No, I just wanted to thank everyone, on the panel, and thanks for the opportunity to speak here. In terms of the concluding remarks, I would just end where I began, in the sense that there's no right or wrong to this answer. And as states, certainly, we should, India or any other sovereign state should carefully think and negotiate these treaties. Certainly the approach that India had adopted in the 90s, and I've been, again, looked at those issues very, very closely. That was not the correct approach, like blindly signing treaties just as photo ops, or just because somebody official or a minister pushed for the signing of such a treaty. I mean, that's not the right approach. Certainly a lot of thought, a lot of policy making, a lot of legal and economic policy making has to go behind the signing and negotiation of the treaties, which thankfully is happening now, and which I'm sure we are all glad to see. So with that, I mean, that's all I have to say. Thanks again.
Thank you. Thank you, everyone. Over to you, Pratik. We have come to the end of this. I know time is up.
I'd like to thank all the panelists for a really exciting discussion over the course of the last hour, and Mr. Misra for really directing it in a manner where we could explore the various aspects of the topic, not just the one side or the other side, but really dive into the cases and the practical experience of the panelists as they spoke to really flesh out the issue. So thank you, everyone. Thank you, Mr. Misra. Finally, just for the benefit of the participants, the video recordings and the transcripts of this session will also be available on www.adrweek.in, which is the official website of this event. I believe I speak for all the panelists as well that we hope to catch up in person fairly soon in the near future. Thank you all.
Thank
Thank
you.
you. Thank you, everyone. Thank you.